I think this falls within a hearsay exception. Because they're trying to prove that he started the fire, right?
Well,
So it's hearsay.
yeah, I think it's A.
Really?
This is a 609.
I was thinking it was
Prior conviction
B
bad act.
because you admitted it was proof that the defendant had set the fire. I don't know, I may be wrong. Because it's a prior conviction, right?
It's a prior conviction, but can you do action in conformity with a prior conviction? I think 404 says that you can only use prior convictions to show motive, intent, or plan, not action in conformity.
But isn't this the same set of facts, though? So he set fire to like an antique shop, and then he's prosecuted for it.
Mm-hmm.
Oh, we'll go to the answer. I'm probably wrong. Who knows? Who knows? It's B. The record of the defendant's conviction should be admitted to prove that the defendant set the fire. The record of conviction is hearsay. It is a statement other than one made by the declarant while testifying at the trial or hearing, offered to prove the matter asserted under federal rules. However, such judgment fall within the hearsay exceptions. For records of felony convictions under federal rules, judgment of felony convictions are admissible in both criminal and civil actions to prove fact essential to the judgment.
Under what rule does it say?
Whether judgment arose after a trial or upon a plea of guilty. Federal Rule of Evidence 803-22. It's one of those hearsay exceptions where the declarant's unavailability is immaterial, right? I think. Remember, Remember, it was one of the 35 hearsay questions that we did to prove that person.
Really?
Yeah. Here, let me see. As proof that B had committed a prior bank robbery, evidence that she was prosecuted for that crime, and that a jury had found her guilty. 16 hearsay.
Okay.
Because it is conduct intended as an assertion. And then here's one of the exceptions to get it in.
Okay.
I don't know, maybe, I mean...
I got you. Yeah.
I don't know, I guess the reason I'm familiar with it is because of that question, because it was on the...
Right.
One of the questions asked. Ready for it?
All right, I think you can eliminate C because you don't know the subject matter of direct. Right?
Well, the direct examination, yeah, I'll ask him.
He doesn't say anything about what he asked him. Well,
So the defense attorney cross-examined the witness for 3 days, told the court that he planned to spend at least another day in criminal.
but this is a criminal trial.
Right, so testimony... Yeah, I mean...
I don't think just because the evidence is.
I agree with you that C is kicked out because we don't know them. Yeah.
And and M and B, who's to say what's adequate? I think it's either A or D, and I'm moving towards D, but I don't have a good rule to point to.
Yeah, nor do I. In some sense, I feel like they're very similar. Well, I mean, I guess I'm going to go with A because we never really talked about judicial economy. But we'll see.
I think judicial economy might be one of those other.
Oh, you're going to laugh? It's B.
No freaking way.
Yeah. Oh my gosh.
Okay.
Yes, because the defendant had an adequate opportunity for meaningful cross-examination. Although the party is entitled to the right of some cross-examination, the extent or scope of examination is a matter of judicial discretion. The judge may exercise reasonable control over the examination of a witness to aid the effective ascertainment of truth, to avoid wasting time, and to protect the witness from harassment or undue embarrassment. Specifically, the trial court has the authority to cut off examination when it determines there has been adequate opportunity for meaningful examination.
I think it's a badly written answer. I think it should have been.
Here's
if the judge determines the defendant had.
Here's Rule 611B. Cross-examination is limited to 1. Matters brought out in direct examination and inferences drawn therefrom, and 2. Matters affecting the credibility of the witness.
611 is also what talks about the judge has the discretion to stop examination of a witness if it's, too burdensome on the witness or too harmful to the witness or something like that.
Right.
Thoughts?
I don't think it's hearsay.
No. I don't think so either.
Because I don't think it's A. I don't think it's C. B or D, what do you think?
I think it's D.
D.
I think it is probative, although it might not have much weight.
Yeah, I guess it'd just go to the jury, right? There's evidence sufficient to sufficient to support a finding. So it goes to the jury. I'll check it out. 5. Yep, D. The word craftsman is not hearsay, and the wrench is relevant circumstantial evidence on the issue of whether the defendant dropped the wrench that struck the plaintiff. Evidence is relevant if it tends to make the existence of a fact of consequence to the action more probable than it would be without the evidence. If the defendant uses craftsman wrenches on the job and the wrench that struck the plaintiff bears the brand name craftsman, it is more probable than would otherwise be the case that the wrench that struck the plaintiff was dropped by the defendant. Thus, the wrench is relevant probative that the defendant dropped the wrench. The wrench is circumstantial rather than direct evidence because the fact about it is being proved as based for inference about another fact. If another fact is true, the fact that the wrench bears the name craftsman is proved to form the basis for inferring the defendant dropped the wrench. Direct evidence is offered to prove the fact of the object. Okay.
Substantial depends on another fact being true. So the craftsman is only relevant if it can be proven that all they use is craftsman wrenches.
Right.
Oh. Okay. Why is the craftsman not hearsay?
Because it is a logo or an inscription of a company. And it doesn't have to be a well-known company either.
Right. Just in the normal course of business.
Normal course of business. And remember, if it was an inscription that was of a person's name, then it would be hearsay.
Right.
Such as Witter.
Yeah.
On a cup.
If they'd have said, yeah, it said craftsman, and the worker had also etched his name in the side, then etching the name would be hearsay.
Yeah.
No.
She's trying to prove that she assumed the risk. Foreman testifies that he told the plaintiff not to use the fireplace 24 hours, allow the chemicals to evaporate.
It's exactly like that one we have in the book.
Oh my God, what's your rest gest date again?
I don't know. I don't remember.
Oh, is he testifying in court?
Yeah.
So is it A?
I think it's B. I mean, the declarant still testified to his out-of-court statement.
Yeah, it is B. The evidence is not hearsay because the statement is not offered for its truth. The statement is offered to show the effect on the listener.
This is the one where the one in the book where it says to prove that C assumed the risk of driving D's car, evidence that D said something about relining his brakes or something. I don't think it was. It was effect on the listener. You ready?
Yep, let's do it. Yeah. Oh, darn. Computer just ran out of power.